Good morning. Today is July 30th, 2026, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan. Every Thursday morning, Kimberly Best, Felicia Harris-Haas, Jean Lawler, David Schraga, and I are delighted to host another cutting-edge webinar for mediators. As you know, there's no charge for these great programs. Rather, we ask you to contribute to a food bank if you like what you see. And since we began the series in 2020, our generous audiences have been fabulous in contributing in honor of our great speakers. One of my favorite parts of the webinar each week is when we announce the running total of just how much our audiences have contributed. Jean Lawler, would you please do the honors?
Always my pleasure. Sure, happy to do that. And I'm especially happy to say 1 million to start the number with. So anyway, as of today, we have been advised of donations to food banks around the world through the Will Work for Food program here of $1,014,021.28. And so that's fantastic. Please let us know what your donations are, and thank you all for your generosity.
Thank you, Jean. That's an amazing number and generosity indeed. Today we have another great presentation, Meditations on Mediation, a conversation with the former federal judge, now mediator, and former corporate general counsel. Today we'll have a conversation on the practice and experiences with mediation from the perspectives of the Honorable Tony Leung, U.S. Magistrate Judge retired, and Ivan Fong, formerly Executive Vice President, General Counsel, and Secretary of Medtronic. They will explore how they approach high-stakes dispute resolution, what makes for a successful mediation, and implications for the rule of law. To give you a bit more on background, the Honorable Tony Leung, retired, is the owner of LeungADR LLC, where he focuses on mediation and arbitration. Tony is a nationally respected neutral. He served for 31 years on the federal and state benches, including 14 years as a United States Magistrate Judge, resolved hundreds of complex disputes involving commercial, employment, intellectual property, construction, healthcare, class actions, mass torts, and other high-stakes matters. Before joining the bench, he was an equity partner at Faegre Benson. Firm is now called Faegre Drinker Biddle Reath. He earned his undergraduate degree from Yale University and his JD from New York University School of Law. Ivan Fong is an independent board director of CBOE Global Markets, a leading provider of market infrastructure and trading, clearing, and investment solutions. He is also the treasurer and on the council of the American Law Institute. As a director of the Center for AI and Digital Policy and LCLD, and on the Leaders Council of the Legal Services Corporation. Ivan is a former executive vice president, general counsel, and secretary of Medtronic, executive vice president, chief legal and policy officer, and secretary of 3M, General Counsel of the U.S. Department of Homeland Security, Chief Legal Officer and Secretary of Cardinal Health, Deputy Associate Attorney General at the U.S. Department of Justice, Adjunct Professor of Law at Georgetown University Law Center, partner in Covington and Burling, and former law clerk to Justice Sandra Day O'Connor of the United States Supreme Court. He's a graduate of MIT, Stanford Law School, and Oxford University. Wow, what a couple of powerhouses. Tony, Ivan, please tell us a little bit about the food bank to which you would like people to contribute if they're able to do so. And then on with the presentation. The floor is yours.
Sure, I'll start. Second Harvest Heartland is one of the longest running and stable food banks in this area. And it's just a very solid program where you know that your contributions are going to be used in a very efficient, effective way.
And
Fabulous.
for me, I also support Second Harvest. I have done volunteer work with them. And as Tony indicated, they do terrific work. Now that my wife and I have moved to Seattle for retirement, we are trying to look for places to volunteer. One of our good friends who lives in the next town over, which is Edmonds, volunteers with the Edmonds Food Bank. So I told him that we would try to get some support from this group for the Edmonds Food Bank in Edmonds, Washington, also doing terrific work.
Terrific.
Thank you all.
And now the meditations on mediation.
Should I take it first?
Sure.
Sure.
I think I'll start the program by basically outlining some basic theories and modalities of mediation. And so when I talk about theories of mediation, I'll start with my simple goal in a mediation, and it's to help the parties find the intersection of their own respective self-interests. And when I say an intersection of self-interests, I don't mean pi. It's not that precise. It's not like 3.14159 and so forth. Basically, that intersection of self-interest means to me both parties in the same ballpark. I always say if we have both parties in the same ballpark, they can be on different ends of the stadium, but we should be able to get that settled. Now, of course, if the parties end up in being different universes, there's only so much we can do, and we won't settle, at least not today. So to me, that's my basic approach to mediation. And I think and this may be a little fundamental background, but mediators should know the difference between the different approaches, of course, of mediation. Facilitative, interest-based, evaluative, position-based, transformative, and I believe that a good mediator will be familiar with all of those approaches. And have the flexibility and creativity to insistently transition between those different modes of mediation. I think mediators should have a basic understanding of game theory, for example, but ultimately, mediation is really a mix of art and science. And so I believe a good mediator just flows with what the folks want to talk about. Of course, internally, I'll have a structure to guide people, but I try to let the parties themselves lead the flow of the issues that they want to approach. Next, I think I can provide what I call the basic nuts and bolts of mediation. And again, this is pretty basic background, but I think it's a good way to start this podcast. The first thing I think about when I think of mediation is timing. To me, the timing is the balance between attorney's fees and information and the procedural posture of the case. I think all of those have to be considered when you're thinking about, okay, is it the right time? Participants. Okay. Basically there you have parties, class reps, attorneys, decision makers, governmental officials, if it's a public sector case, insurers, investors. And I want to comment a little bit more about the investors because I think investors provide a unique challenge in mediations. First of all, even if I were in the court, it's actually not that easy to get investors to participate. And the other difficulty is, and this is just my thinking about it, is to me, their objective is a return on investment. And that's the key driver that they have, rather than settling the parties' individual dispute in a manner that these parties can live with. So it's a very different paradigm in my mind, and I think that makes it challenging for mediators. And The other aspect of investors and the idea of return on investment is that their risk is diversified through many cases. It could be hundreds of cases, maybe thousands. I'm not sure of that, but they're diversified through many cases rather than analyzing the case on a one-on-one basis. And again, that makes it pretty challenging for parties to, resolve their own disputes if there's someone hanging in the background. Preparation, I think, is another area that is very important. Learning about the parties, you analyze obviously the laws and the facts. I think in the appropriate trials and significant trials, you'd go do mock-ups in preparation and see what the information is from that. If the parties are willing to share it, that's very important. Obviously, insurance probably one of the most critical things in modern American litigation and settlements. Getting doing your homework on reservations, wasting policies. Does the defendant have runaway verdict insurance? Does the plaintiff have verdict insurance? Okay. I always prepare in advance a rough range too, which that ballpark I was talking about, the intersection of self-interest, I always prepare in advance a basic range. Now, in the end, sometimes during the mediation, if we end up talking in ranges, it could be within that range or it might not. And again, I try to flow with the conversation of the parties. The manner of the mediation is important. Is it going to be in Zoom or in person? If it's in person in high profile cases, that's quite important to figure out where you're going to do it because, if in a high profile case, if media sees certain people going to a certain location and they may be well watching for that, that creates an outside distraction that I think is not helpful. And so, especially in those high profile cases, the location is very important. And then finally, I'll end by saying that I think of mediations almost like a movement in a concert. There's a first section, the first movement. That's where I always start by trying to inspire the parties that settlement is attainable. And, I give them a pep talk and remember that kid's character? His name is Bob the Builder. Yes, we can. I don't know if you remember that, but I give him the yes, we can speech. There's also a middle movement or section. That's where we're running from room to room, whether it's an actual physical room or a virtual room. And that's where we do our shuttle diplomacy, or I've heard some people call it being the high-paid messenger from room to room. But I prefer to call it the vehicle of communication, I guess. And during that, it's very important, I think, that certain skills be employed during this shuttle diplomacy section. You have to be a good listener, observer. You have to convey empathy, extremely important in certain types of cases. I think in all cases, building trust and building the idea that you are a fair person and you view things fairly, and building that rapport and respect and authority too. I think all of those are important skills that you utilize that you have to be mindful of when you are moving from room to room. And then lastly, I'll say, basically go back to the idea of flexibility. There's a certain dynamic fluidity of these complex negotiations and the entrenchment of the parties. All of that requires a certain fluidity in the mediator and how you close deals. What do you do to try to break impasses? Of course, there's many different tools that we can employ, apply, and I think another aspect of it is memorializing the deals. How do you do that? I can tell you from an experience just yesterday on a video Zoom, we had the deal all agreed to. One side had signed it, and because now I'm a paid mediator as opposed to a free mediator when I was on the bench, I thought, okay, things are going okay. All right, did you send the document? So one side had signed it, the other side, was gonna, and so I logged off. And so there was a little bit of a glitch, but then things are, I believe things all together now. So again, how do you memorialize the deal is important. And at the end, if there's no deal at the end of the mediation, that's fine too. Now that's not a problem because again, you can always circle around to it later, and sometimes people just aren't ready for various reasons. I'll finish by saying, what's the difference between being a mediator as a judge and in private life? It's basically the robe when you think about it. I can tell you, I cannot keep people around if they don't want to be there. And so, as a private mediator, I think the latest mediation I had was until 9 o'clock. No one really wanted to be there after 5 o'clock, but I think everyone has sense we were going to do the deal. But it took, there's a lot of details we had to work through. So, as a mediator, 9 o'clock. As a judge, I had a number of them that lasted until after midnight. And the latest I ever did one was we settled the case at 2 in the morning. Those don't happen as a private mediator. By the way, the late night ones all settled. So, anyways, I've said enough, and so I want to leave some time for the others and Ivan.
Sure, I'll pick up from where Tony started. But first, I just want to thank Jeff for inviting me to speak. This is what happens when you sit next to Jeff at an ALI lunch. Thank the Will Work for Food team for hosting this program. And I also want to thank Tony for doing this with me. Tony and I have known each other for many, many years, and we always enjoy talking about mediation and rule of law and theory and practice. So it's a treat for me. I also see a number of friends and former colleagues in the audience. So greetings to all of you, and thank you for coming. I speak from the perspective of not a mediator. I've never been a third party neutral, but I have been a strong proponent of mediation as an important dispute resolution tool in the toolbox. And I'll start by saying that when I've proposed mediation, I get often some pushback, and so I wanted to start by saying to parties, and I don't know if this is relevant to mediators, but I tell my internal clients, we should not be afraid to mediate a dispute. There's sometimes a sense or a fear that saying that we're willing to mediate is a sign of weakness, that somehow we're not ready or prepared to go to trial, and we don't want to do that. And I respond, well, if we can resolve this dispute early, we'll save money. The great benefit of mediation, as all of you know, is that it's not binding. So we still maintain control over whether we want to settle on these terms. So it's really a low cost way of seeing whether or not there's a solution to be had. And then I remind our internal stakeholders that the company has a purpose and a mission, which is to save lives or sell widgets or do something good in the world. We do not exist to pay expensive inside and outside lawyers to resolve disputes. Now, there are exceptions which we may get to, where there's an important matter of principle or policy that we're trying to vindicate. But most cases are ones that really should settle because it's just not worth spending time and energy resolving something that's really at the periphery of what the business is all about. And then finally, just as a pure risk management tool, I usually say this to the CFO, we can spend a lot of money and get to an outcome, or we could spend maybe a tenth or a fifth of the amount. As all of you know, going to trial these days, the discovery process, it's all become so expensive. And it's not saying that mediation is cheap. Sometimes mediators can be very expensive. But by and large, it's just a great way to reduce risk. When you go to trial, you often say, we're throwing the dice, or even, engaging in motion practice. You may have a judge who, may rule. It's hard to predict sometimes how courts will rule. And so there's risk on both sides. And in those circumstances, I think enlisting the assistance of a third party neutral can be a way to get to an early resolution. The second point is after you sort of convince the internal stakeholders that this is a good thing, you have two very practical questions. One is, who should staff this process on the inside, and how do you select an effective mediator? On the first one, I don't think there's a rule that I practice. I think I've done it both ways, which is either to have the same team working on the case, also engaged in the mediation. But I've also found it to be successful when you have a separate team, because it's in part to navigate through or offset this sense that we have to be always working the litigation angle. We have to show that we are prepared to take this all the way through, and so you need a separate team. Often when you're engaged in the settlement negotiations, you're doing it, in the midst of trial preparation, or sometimes even ongoing a trial. And so you don't want to distract or, take the time away from the trial team, but you need a separate team to really think creatively about whether there's a resolution to be had. And so I'm often in the position of finding sort of someone else, somebody who doesn't know anything about this case, who can look at it with fresh eyes and help explain to the mediator sort of what this case is all about, and let the trial team continue to pursue discovery and motions. How to select an effective mediator? I think Tony sort of mentioned sort of the main things that I look for. I'll start with sort of a threshold question, which is, are there any conflicts? I don't want a mediator to have conflicts. I also look for a track record of successful mediations in this kind of dispute or this space. I look hard for somebody who has this sort of art and science mentality that Tony talked about, the understanding of human psychology, because as Tony indicated, one of the real motivators or drivers of a successful mediation is having a mediator who is able to quickly assess and leverage sort of the underlying motivations and interests of the parties. And then third, I look for creativity. Tony called it flexibility. I think of it as somebody who is able to look beyond the pure dispute or the core to the dispute and find those elements of a deal that are non-monetary. So usually if it's a dispute about money, you end up in this sort of very binary or linear bargaining of, you're at some number, I'm at another number, and we're trying to find a number in the middle. For me, I really value the ability to find something to trade that costs one side very little, but is worth a lot to the other side, or vice versa. I would be willing to take something that maybe is not very um, meaningful to you, but it would mean a lot to me if you were to do X or to commit to do something. And so taking the dispute out of a binary or linear frame is often the way to break through a dispute where the parties are very far apart.
Excuse me.
And then finally,
Ivan,
go ahead.
can you think of an example or two? Because we mediators are always looking for these kinds of trade-offs, and they're often very difficult to find. From your experience, what have been a couple of real home run examples of that?
Sure. I'm not sure these qualify as home runs, but they're small, and it ties into this last point I was going to make about timing. I think the timing of these non-monetary elements are important because starting with them can feel like an insult. And so, with that caveat, two examples. One is a classic one, which is an apology, which companies and clients are sometimes loath to do because they think, oh, this is, an admission of liability. It's going to make us look bad. And but that's often something that if it's an employment dispute or single plaintiff where um, some harm has occurred and a company that takes responsibility, owns up to it, and says, I'm sorry for this. Uh, we wish it had never happened. We're going to try to make it right, and we've improved our processes to make sure this never happens again. I think that can be something that a potential plaintiff will value. Some potential plaintiffs. A second example that I have used is also in an employment context where uh, this person really was somebody who was valued and contributed a lot, and we wanted to recognize their contributions. So again, I'm going to modify the facts a little bit to preserve confidentiality, but uh, something like designating a conference room in this person's name with a plaque and a ceremony and pictures, so that everybody will remember this person and what they did. Funding a scholarship in this person's name to create a legacy of contribution and goodwill. There's a third example that comes to mind, but it's of a similar sort to the scholarship idea, or creating a fund that will be used to benefit the community in this person's name. And again, cynics will say that this is just a way for the company to sort of buy its way out of taking responsibility. But I do think human psychology is such that sometimes people want to be recognized and acknowledged and seen, and uh, want to come away from this process without feeling like, okay, I extracted the last dollar. Um, Sometimes you just can't get there because people are dug in and they just want to win. And I think coming back to the topic of a good mediator who who is a bit of a therapist and can say, look, there's a bigger picture here that this is not about revenge, but this is about doing something that will leave the world a better place, and that's what you want. That's what the company wants, and so let's let's try to come up with something that will fill that scratch that itch.
Jeff,
Go
I
ahead,
have an
Phil.
example I like to use is years ago I was mediating an IP case and it involved navigational technology, marine use of that technology, and it's a patent suit. And in the end, what we found was that that was the technology at issue. But one of the companies also had another line of business, and that there was a portfolio of patents that that company actually had for other uses, and they ended up. I have to be a little well. It's been a long time, and I'm not naming a name, but we ended up exchanging licenses and mediating the suit. But it was literally taking marine use, applying it to other uses, and then exchanging a portfolio on the other side. So that's I think a good example of that. The other area that I think lends itself to that type of creativity is a lot of times in the what I call the public consumer, fraud and those types of areas. There's litigation sometimes that's more for protecting the broader community, and those types of lawsuits lend themselves to that type of creative resolution.
And then when you're offering apologies, for example, how do you protect yourself, Ivan or Tony, from having it look opportunistic? Like, okay, I'm sorry. Now will you take less money? You don't want it to come across that way in the plaintiff's room. How do you protect yourself against that perhaps reflexive reaction?
Sure.
I think it's very difficult. I think that timing is, as you say, important, and the I think it has to come from the other side or the plaintiff. I do think as a defendant, if you're offering that up, it can sound cheap and um, sort of dismissive. So I don't always lead with that. It's something we keep in the back of our pocket, and at the right time, if again there's some internal resistance. So it's a balance. It's a threading of a needle that we'd have to carefully word it, and that can sometimes crater this as an element because we've all seen those carefully worded apologies that really don't amount to very much. So I don't want to offer that out as a cure-all. It's certainly not a panacea, but I have seen it work in narrow, special circumstances. Again, where somebody really has some loss of dignity, and that's really what they're trying to regain. And it really doesn't cost, in the grand scheme of things, the company that much. Again, you have to negotiate with your internal stakeholders, the communications team, or sometimes even the business leaders who are convinced that we did nothing wrong. So why should we apologize? I'd rather write a bigger check or take our chances at trial or in litigation. So, but again, I think it's worth floating, at the right time because um, it can be part of a larger package.
And does these kinds of creative solutions, whether it's an apology or licensing deal, you often have to pick up on subtle cues in order to know that it's time. Is it easier to do that when there are direct communications or what we sometimes call joint sessions between the parties, as opposed to simply the mediator shuttling back and forth? That is, I find it hard to imagine that a mediator coming in and saying, by the way, Mr. and Miss Plaintiff, Mr. Fong wants you to know he sincerely apologizes for whatever. I doubt that that is going to be as effective as you doing it yourself. So, what about the role of direct communications and the ability to pick up on these subtle cues to find out underlying interests and emotional needs?
I can try to take that on. Uh, First of all, yeah, going back a little bit to what Ivan was saying, I think the idea that the combining the reminding in a um, in a thoughtful way that the apology, for example, comes together with other elements of a settlement, and that combination is more powerful and more meaningful in that sense. And I also go back to earlier when I was talking about the art and science of mediation. I think there's a lot of art in this part of it, and I think it's so important here to remember mediators need to build rapport and the trust and that sense of fairness and even that sense of gravitas or authority. And that, I think, helps the delivery of that message. As far as the direct communications, I am always so afraid of that, in all candor, because, you just don't know exactly what people are going to say. But that's exactly what you need to manage is that, I think when I've done that, and I don't do it a lot, I know I've scripted it out almost for both sides, what exactly is going to happen, who's going to sit where, who's going to do the talking, and then even have them say in advance, what am I going to say, right? And then sort of get everything prepared because it's really risky because I've tended to use that at the end to close the final loop. And so I don't want to blow it too because we've done a lot of work till then. But yeah, I think you're absolutely right, Jeff, is that it's hard to beat that direct eye-to-eye communication on a topic such as an apology, for example.
I agree with Tony. I was going to say that it's not always one or the other. It can be a two-step or a three-step process. So, in my experience, typically before the parties engage in mediation, there will already have been preliminary conversations between the lawyers, and one of the reasons for bringing in a third-party neutral is that there's an impasse or there's no obvious solution. And so for me, I really highly have recommended and had success with shuttle diplomacy as step two, because by this point in the dispute, there's already too much posturing and too much emotion. And I've found that if the parties or their lawyers are engaged in direct conversation, the posturing and the emotion gets in the way of the creativity that's required to come up with these third solution ideas. But then, if, as Tony's indicated, the shuttle diplomacy works, meaning, the mediator is able to say to whichever party is really, at issue, here's what the other side is prepared to do or to accept. What do you think? And go back and forth. And then in the final stage, again, as Tony indicated, if it is productive to have that face-to-face direct contact, that can be helpful. But I'd say in maybe two-thirds of the time, you're at the point where I just want to get rid of this. I don't want to talk to the other side. We are not happy. Both sides are not happy. But this is sort of a way to sort of resolve the dispute, and we just want to get on with life. And that if it involves an apology or doing something that we would have to sell internally as a good deal, um, we'll do it, but we're not happy, and that's the usual case. I remember in the government, both at the Department of Justice and Homeland Security, you get these settlement memos written by um, the other side, written by your lawyers, and usually they start off by talking about how great the other side's arguments are, and that's why we have to settle, and that's very atypical of what you normally expect from your lawyers. Normally, the lawyers are writing a memo saying, we have all these great arguments. Here are some facts that we think will work in our favor. So this is why we should fight this, we should defend this, or we should be a plaintiff. And then when you get the settlement memo, you get the exact opposite. And there's a little bit of an art to writing that memo to say, this is why we should accept this settlement, because the alternative is much higher risk and much worse for us. So knowing that that's what the other side has to do is convince their client that this is not a great thing, but it's better than the alternative. I think that's sort of the art that I'm looking for.
Indeed. Ivan, I know you had other important points you wanted to discuss, so please go ahead.
Sure. Just 5 minutes on a topic that I have been committed to and speaking about, which is the relationship between dispute resolution and promoting a strong rule of law. And I've been out speaking on why companies should support a strong rule of law. I think most companies, at least in the United States, take for granted that we have, judges who are independent, that there is, reasonable access to justice, and our judicial system is functioning well. And I don't think that's true. I don't think we are providing sort of good access to justice these days. And I do think that companies have a stake in making sure that there is good rule of law. And by that I mean disputes and decisions that are made based on the law, not on arbitrariness or based on one person's preferences. If you're part of a global company, one has to decide whether we want to invest in that company. And I think the lawyer's job is to assess whether or not we can get disputes resolved fairly and efficiently in this country, whether our contractual and property rights, and particularly IP rights, will be enforced and protected in a predictable way, and then whether we can live with a certain amount of arbitrary government action. And if the answer is no, we don't think that's a good place for us to do business, where we have a solid license to operate, then I think a lawyer should say we should either think twice or have some mitigation in place that we can easily pull out if we have to. And so this is just a long way of saying, mediators, I think, can help, because what you do is essentially what I learned in law school many years ago, which is you're bargaining in the shadow of the law. That's the phrase that a law professor of mine wrote. I think it was an article that became a book. And the idea is that as a mediator, you're not just sort of trying to resolve a dispute, in the air. There is some background law and facts that shape, the art of a possible resolution. And so you could argue that, well, by taking it out of the formal judicial system, you're not really helping develop, the law. But I would argue that, there are scarce judicial resources. So simply conserving scarce judicial resources is a public good. And, by having reference to the legal rules that help, or shape the way the dispute is resolved, I think you are in effect strengthening the rule of law. Because if the parties agree, that indicates or shows that, okay, well, this is, better than or as good as we could get in the system. And that's a sign of respect for and willingness to um, abide by some rule, even if you've not been, compelled to comply. And I know this is a point Tony wants to make, so I'll turn it back to him. But I do think that mediators are performing a public service. That's sort of the main message I wanted to leave you with.
Yeah,
Tony, please.
Jeff, go ahead.
Yeah, go ahead, Tony, please.
Sure, sure. Um, and what Ivan says, I strongly agree with, not only because I now engage in it and have, but I believe that there are very strong philosophical pillars of why mediation is preferred over court or jury trials in the overwhelming majority of cases. Um, Earlier, I outlined what I call the nuts and bolts of mediation, or in other words, the modalities of mediation. So now I'm going to talk a little bit about, the philosophical underpinnings. And, to put it simply, I think of mediation as strengthening the rule of law because it transforms legal rights and obligations into voluntary and more durable compliance because you achieve it through self-determination, right, rather than coerced obedience. And so I'm going to back up and remember in college, some of us read Rousseau's Social Contract, right? Think about it. Mediation can be framed as a form of self-determination analogous to that Rousseauian idea of Geneva direct democracy. So that you can contrast it to the indirect democracy of the decision makers, which is the jury, right? Because there you delegate that democratic process to that jury who's really representing you. And, instead of coming to a agreed upon consented resolution of a matter, the jury in the end gives you a judgment in essence. And so I think there's a lot to be said about mediation as a consensual form of resolution that requires the unanimous consent of the parties. Remember, we have no power. I mean, that's the court, that's the jury who has the power to say this is what it's going to be, and so I think there's a lot to be said about that. And you think about jury trials in contrast. How many times have you heard at the end of a trial someone, the losing party, say, "This is outrageous. This verdict's outrageous. I'm going to appeal. I'm going to fire my lawyer." And sometimes you think about it, even the winning party comes off saying, "Hold it, I spent how much on attorney's fees, costs, experts, jury consultants, and this is what I get." So in other words, those are very contrasting ways to resolve an issue. And I think that's why, those underlying philosophical principles actually add more legitimacy to the concept of resolution through mediation. The parties are in direct participation, and they can decide their own norms of how they govern their disputes. They can obviously have the direct say in the terms of the resolution. And so I'll stop here, Jeff, on as far as that goes. If you want, I can talk a little bit about, some of the higher profile types of cases and maybe some of the unique challenges of those, or if you want to take it to somewhere else, you can take the lead, Jeff.
Oh, we've got a couple. Thank you, Tony. We've got a couple questions in the chat. David Schraga, you have some questions in the chat. Would you like to pose them, please?
Yeah, yes. Thank you both for a great seminar today. And one of the things I wanted to pick up on is Ivan had mentioned when you're in house the importance of being able to go back to the settlement memos and justifying why settlement is appropriate. And I guess this is a question maybe for both of you from both sides. Tony, in your experience as a mediator, when you've got a lawyer on either side of the case who just doesn't acknowledge the risks that you're trying to present or explain to them, there's kind of this, sometimes you feel like they drink their own Kool-Aid, right, to use that expression. What are some of the strategies that you use to try and get through to them or their client, or how do you deal with that problem? And I guess the flip side is, Tony, sort of, Ivan, from being the client, what's effective for you to hear from a mediator to give you that ammunition you need to go back to the client? And what's an effective way to have those conversations when people really feel entrenched in their positions?
Yeah, I'll start on that. I'm going to start going back to preparation. When you prepare for a case, you know what the strengths and weaknesses and risks are on either side. And I think once you know that, you know where the vulnerabilities are with respect to one side. And what I try to do is at that point, you have to respect the lawyer and, with the client there, you don't want to create some, tension, that dynamic. And so what I try to do is ask questions in a very neutral way that gets at those specific points of vulnerability that they have in their case. And I think that's a very effective way of forcing the lawyer, in essence, to come out and talk about that very area that they know that they're weakest on.
I think that a mediator can do a lot to present or find new facts that the party, and in my case, usually if it's the company, the defendant, was either not aware of or did not appreciate. So I'll give a couple of examples. If there's a dispute, one of the things our team will do is interview our sort of witnesses and review our documents, and we'll make an assessment of, does this claim actually have any validity? Is there any substance to it? Is it worth anything? A mediator can help by identifying new facts, really pure things that we just didn't know, or in maybe the more usual case, shed light on how a document or a witness is going to be viewed or come off in front of a judge or a jury. And it gives us an opportunity to assess the credibility of the party or the witness in a way that in sort of this pre-dispute mode, we really don't. I mean, we have, our team's view of the other side's credibility. If it's a business, they will have had other dealings, or if it's a person, there may be some impression that the company has that actually may not be correct. So I'm not saying that a mediator should mislead or engage in sort of too much hyperbole. In fact, I discovered a ABA ethics opinion 518. So for CLE purposes, if you want ethics credit, go read this ABA ethics opinion from October of last year, talking about a lawyer's duty to avoid misleading communications when acting as a third-party neutral mediator. And so I think you do have to sort of present risk to each party, but do it in a way that is grounded in fact and without sort of being an advocate for the other side. And I think I can take that back to my internal stakeholders and say, well, the mediator has said this is the way he would see this if he were a judge or on a jury. And I think we have to give that some weight to give that, use that as a data point and, rethink how much, this case is actually how it's going to play out if we were to continue with litigation.
Okay, thank you. David Geffen, you had a question. If you're here, please unmute yourself and ask.
Yes, unmuted. Hi, how are you? Thank you for the
Good,
presentation.
glad to have you.
Yeah, when there's insurance involved, quite often there's an amount set aside and apportioned and valued for the claim by a third party who's probably not even in the room, and it limits the defendants usually and how much they're willing to offer, and eventually you get to the amount that the limit that they've been assigned, allowed to offer. It sometimes is very disappointing to find out at the end of the day how constrained they are in their authority. I was wondering if there's a way you use to cut to that and to go beyond that authority at an earlier stage so that you're not blindsided at the end of the day.
Oh, shall I try to take that on first? Thank you for that question. Insurance is pretty important in resolution of cases, to understate something. Yeah, it's very helpful to know early on if there are some limits or what the parties are coming to the table with. Now, theoretically, they aren't supposed to be coming with any limitations, and they have the full authority. But the reality is that is actually not always the case. So having that knowledge is important. But I believe we can work with that even without knowing the specific limit of that individual. Because as the mediation progresses, you start picking up a real good sense of where things are. And also, remember at the end, if we do get to a point where you think they're getting to a limit, you can always encourage them to make the phone calls. And often people have at least one person, sometimes multiple layers, depending on the type of case, of people that are available for those phone calls. So that, broadens the scope sometimes of what's available. And finally, there are many situations where, yeah, they came in with whatever authority and it ain't going to work at that level. And those are times when I think it's helpful for a mediator. You have to be careful, but I think it's helpful for a mediator if you share with that adjuster in front of their clients and the lawyers that, hey, this is what we're looking at, and sharing that adjuster at the table, I think automatically will go up. Let's say you end the session. That adjuster is going to go home and talk to whoever that person's boss is. And, if you have a mediator that is well respected and, has good reason for what they're thinking, that often will change whatever the limit was that those folks came in with. And it's not that unusual to have a settlement. You leave it open for, 2 days, 3 days, 5 days, and it's not unusual for people to reach the deal after that.
Okay, one final question. We have just a minute left. You both said that sometimes a case doesn't settle, and from your perspective, that's okay. But for most mediators, when a case doesn't settle, it's sackcloth and ashes, and we're moping and depressed for days. What is the right way for a mediator to judge whether a mediation has been a success? Ivan?
I think if you tried and made your best efforts, it's not your fault that the case didn't settle. It's just not the right time. There needs to be more discovery, more healing, more talk internally. Um, Sometimes judges need to rule so that the parties see, okay, well, we've lost our summary judgment motion, our motion to dismiss, so the risk has just gone up, and so we're willing to pay more. Sometimes plaintiffs need to see that, maybe this case isn't as strong as their lawyer thinks it is, and maybe they should accept something lower. Half a loaf is better than no loaf at all. So I wouldn't view it as a failure. I earlier talked about sort of a track record, but I say that with a grain of salt to say, really good mediators maintain credibility. I think that's sort of at the end of the day, going back to the earlier question about how do I sell this proposed resolution internally. If I have a really credible mediator who is saying, look, this really is the intersection of self-interests, even though it doesn't feel like it at the time, that will carry some weight. And if we just can't get there, it just may be that the stars haven't aligned, and we'll have to come back to you at a later stage.
Fair
Tony?
enough. Tony, 25
Sure.
words or less, please.
Sure. Yeah, obviously, I feel badly when the cases don't settle after I've mediated it. But I also think it's important to keep the big picture in mind. One is that in complicated cases, in big cases, it's actually in many ways, you sort of should expect there's going to be a couple of sessions. And in between sessions, the mediator is going to be doing a lot of work in between as well, not just at the mediation session. So keep that in mind. Secondly, it's part of a process. So if you contributed as a mediator to the process and gotten people to think about their case, to challenge what their previous positions were or assumptions or thoughts are coming into the case, I think you've advanced the ball. And then remember, in the end, it's the process, and in the end, only less than 1% of cases in federal court in civil cases go to trial. Less than 1%. So therefore, when you think about it, it will get there. This is part of the process.
Thank you. It's a very stimulating, fascinating presentation by the two of you. Ivan Fong, Tony Leung, thank you so much. We appreciate it very much. For those in the audience, please consider supporting the Second Harvest Heartland Food Bank in Minnesota or the Edmonds Food Bank in the state of Washington. We look forward to seeing everyone next week. Tony, Ivan, thank you again so much. And with that, we are complete.